on her toes. But thank you, everyone. Welcome to this session of Oakland on the Road. It's very exciting to have this educational opportunity in a virtual format this year. And it's really my great pleasure to introduce our speaker, Sal Amendola. He has been a member of the Trust and Estate Group at Gianmarco Mullins & Horton PC since 1996. And he's also an adjunct faculty member at the WMU Cooley School of Law. And he's been doing that since 2016. He focuses his practice area on estate planning, post-death trust administration, and planning for retirement benefits. Frequently, Sal is invited by professional organizations and nonprofits to share his expertise on all types of matters related to estate planning and charitable gift planning. Today, it is my pleasure to introduce him as our speaker in OU on the Road, as he tells us more about trusts, how they work, and some of the many beneficial ways to utilize trust arrangements in your estate plans. Sal, welcome.
Well, thank you for that introduction, and thanks to Oakland University for having me present this evening on trusts, what they are. What we'll do first is we'll take a look at the legal definition of a trust. This may be the wordiest, or at least the part of the presentation that contains the longest words. We'll try to keep it simple after this, but just to be official, legally, the definition of a trust is a fiduciary relationship in which one person is the holder of the title to property, subject to an equitable obligation to keep or use the property for the benefit of another. That might not have been what you were thinking about, but that's how the law looks at a trust, and the key there is fiduciary relationship. And maybe the best way to go at this is to take an example. A transfers legal title to property to B for the benefit of C. A has created a trust for C. The name for A can go with settlor, grantor, trust maker, trustor, the person creating the relationship, A. The person receiving the property from A is B, the trustee. The trustee holds legal title to the property. That means the trustee can decide whether to hold the property or sell the property, invest the property, reinvest the property. All the benefits of legal ownership that you're used to is what's bestowed on B as the trustee. But B isn't free to use the property for himself or herself. B has a duty, by way of the trust relationship, to use the property for the benefit of C. In our example, that's the beneficiary. C can be an individual, a charity, even a pet, and even a purpose. So, for example, if I had a very fine auto collection that I wanted to see maintained and curated after I passed away, I could actually set up these days something called a purpose trust. I could fund it with enough in terms of assets to allow for the continuation of that collection, its preservation, so on and so forth. Whether it's an individual, charity, pet, or purpose, the beneficiary holds that gives the beneficiary the ability to sue the trustee if the beneficiary believes the trustee is not administering the trust properly. So legal title is in the trustee. Equitable title, the right to demand that the trustee perform the trustee's duties diligently, expeditiously, is in the beneficiary. Let's take a second example. A transfers legal title to property to A for the benefit of C. A has again created a trust for C. But this time, A fills two roles. A is the settlor and the trustee. C is the beneficiary. One more example to show how even all three roles can be filled by the same person. A transfers legal title of property to A for the benefit of A. A has again created a trust, but this time for A. A is all three, the settlor, the trustee, and the beneficiary. And I'm guessing you probably didn't look at it this way, but if you have what's called a revocable living trust, or sometimes a revocable trust, or sometimes just living trust, your trust pretty much mirrors what we just saw in example 3. You conveyed property to yourself as the trustee and the settlor, And you hold the property as trustee for, at least for starters, the benefit of yourself. That's how your revocable living trust works. You're the initial beneficiary, and then after you become incapacitated, or more likely after you pass away, the assets in the trust that you created go on for the benefit of other beneficiaries, presumably either your spouse or your children or your other intended heirs. And don't forget the other beneficiaries on the list, charities, pets, or even purposes. Your trust is revocable because you retain the right to take the property back. On the other hand, if you create a trust where you give up that right permanently, that's called an irrevocable trust. We'll take a look at irrevocable trusts in a little while, because those are important when it comes to getting tax benefits. If the transfer occurs at your death, so for example, maybe you didn't do a living trust, maybe you have a trust built into your last will and testament, that's called a testamentary trust. If the transfer occurs while you're living, that's where we get the term living trust, or in Latin, inter vivos trust. So if you're creating the trust and you're alive, and your trustee is also in existence, it's called an inter vivos, between living beings trust, more commonly living trust. And just a note, a living trust can be both revocable or irrevocable, because you can set either one up while you're alive, but more commonly living trust is used for the revocable type, the one that if you've done any estate planning, because they're so common, the one you probably have. Real briefly, trustees have a number of duties. We already touched on this when we saw how beneficiaries have the ability to compel a trustee to fulfill their duties. What are those duties? Well, here are just a few, and you can see it's an extensive list, and I'm still referring those to just a few. If you've been appointed a trustee, just as a tiny aside, think twice whether you want to accept the appointment, perhaps for a friend or a family member, because you're stepping into all these duties and more, and you're kind of putting yourself in the line of fire. A lot of times, even as drafting attorneys, we'll shy away. So be sure you know what you're getting yourself into, because once you take on that role, you better be sure to be fulfilling all these duties. One, to carry out the terms of the trust according to how the settlor wrote it. You have to carry out the settlor's intentions as best as those are expressed in the trust document. Two, you have to preserve and protect trust property. So, for example, if the settlor put his or her home in his or her revocable trust and then passed away, if you're the next trustee, you have to step in and make sure that the insurance on the home is maintained and doesn't lapse. You probably have to change the locks on the home to make sure no one who may have been given a key in case of an emergency still has the ability to get in and potentially, unfortunately, steal property from the home, and so on and so forth. You have the duty to invest trust property prudently. Now, that's not something that maybe a lot of us know how to do, but that's okay, because trustees can hire out that job to professional investment advisors. You obviously have to be loyal to your beneficiaries. If you're the trustee and you're making side deals with trust property, selling trust property to yourself at fire sale prices, that's not going to fly. Another duty on the list is to be impartial among the beneficiaries. Many times, there'll be what we'll see in a few minutes, present interest beneficiaries and future interest beneficiaries. The present interest beneficiaries are those who are entitled to trust property now. Future interest beneficiaries, no surprise, are entitled to trust property later, typically when the present interest beneficiaries pass away. So how do you invest for a situation like that, especially if you're only allowed to distribute income of the trust to the present beneficiaries? Do you invest to produce a lot of income? That'll make the future beneficiaries upset. Or do you invest for growth and less income? That'll make the present beneficiaries upset. Now you can see a little bit about what I was saying before about this not being a very easy job for trustees. So there's a balancing that has to occur, and you have to try to be as impartial as you can when dealing with beneficiaries. You have to keep accurate records and account to the beneficiaries. You have to be able to tell them upon their request what came in, what went out, what the value of the assets were at the beginning of the year, what the value of the assets were at the end of the year, and all throughout. And last but not least, at least once a trust becomes irrevocable, and sometimes not even then, but sometimes yes, there's a mix there too, more than we can get into tonight, the trustee has the duty to file income tax returns on an annual basis and pay those income taxes to both state and federal authorities. How do trusts work? Let's take a little bit closer look at that. As I mentioned already, interests in trusts are classified as present interests, the now beneficiaries, and future interests, the later beneficiaries. Let's take a look at an example. A transfers stock to B to pay the dividends to C annually for C's life. At C's death, B, the trustee, is to deliver the stock to D. C has a present interest because C can receive distributions now. D has a future interest. Upon C's death, D is entitled to the balance of the trust. Sometimes we call that the principal or the corpus of the trust. C being entitled in this example to the dividends, which we typically refer to as the income of the trust. Dividends, income, rents, and royalties are commonly what we refer to as income. In case you're interested, capital gains can fall into either one of those two, either income or principal. That's a little bit more than we need to cover, though. If the trust contains a spendthrift clause, and nearly all of them do, neither C nor D can transfer their interests to anyone, including creditors. So if someone came up to C and said, "You have an income interest in this trust that I'd like to purchase from you. Would you be willing to sell it to me?" C's response would be, "I'm prohibited from doing that by the terms of the trust." That's a spendthrift trust. Now, why would we want to include a spendthrift clause and make a trust a spendthrift trust? Because maybe we want to put limits on how much a beneficiary like C is entitled to at any point in time. If C had the ability to sell the interest to an outside party, C could circumvent the trust, getting more than just the income per year. But more importantly, if C were sued by creditors, C's inability to transfer, or sometimes we'll say alienate, C's trust interest keeps those creditors at bay. It's not an asset of interest to them because they can't step into C's shoes and take the income from the trust. Example 2, A transfers various securities to B to pay $20,000 to C annually for life. At C's death, B is to deliver the securities to D. This is called an annuity trust, so a dollar amount that's payable each year for either life or maybe for a term of years, doesn't have to be life, is called an annuity trust. Let's take a look at a different variation. Example 3. A transfers various securities to B to pay 5% of the value of the trust to C annually for C's life. So for example, if the trust is $1 million, 5% would be $50,000 for that year. If the trust went up or went down, the 5% for that next year would be different. So this is a variable pay arrangement. It's got an unusual name. It's called a unitrust. So when we see an arrangement where a percentage instead of a dollar amount is to be paid to a beneficiary for a term of years, for life, that's called a unitrust. That's going to be important in a few minutes when we start talking about tax advantages. So again, flat dollar amount without any variation, annuity trust. Percentage, revalued each year, unitrust. Example 4. A transfers various securities, to B to pay the dividends and or the securities themselves to C for life, the beneficiary, in such amounts and for such purposes as the trustee deems appropriate. At C's death, B is to deliver the securities to D. This is a discretionary trust as to C. C has no ability to tell the trustee, "You earned income this year, you should be distributing it to me, why haven't you? I'm due $20,000, why haven't you paid that to me? I'm due 5%, why haven't you paid that to me?" Instead, C's position is much weaker, and that has an advantage as well. C can go to the trustee and say, "Can I have some money?" Not, "Why haven't you paid it to me yet?" That's the trustee's discretion. That's the trustee's judgment to decide, well, do I look at what C is doing outside of this trust? How much is C in need for? What are the purposes that I'm allowed in the governing instrument to distribute to C? A lot of times you'll find, even in your own trust, a very common distribution standard when we have discretionary trusts is a limitation that says only for health, education, maintenance, and support. So if C came to the trustee and said, you know, my maintenance and support requires a $500,000 Lamborghini, the trustee is very much inclined to probably say, depending on C's standard of living, sorry, mom and dad didn't intend for that. But there's another important aspect to a discretionary trust, whether it has that language, health, education, maintenance, and support, or some other language. It's that they're even better against creditors than the trust that we looked at before. Anything that goes mandatory to a beneficiary, even with a spendthrift trust, is on weaker ground. If I have a discretionary trust coupled with a spendthrift clause, that's the best that we can do against creditors. So for example, if C in our example is getting divorced and C's ex-spouse is coming after C's interest in the trust, very, very difficult for the ex-spouse to get to the assets of the trust because of the discretionary trust provision and because of the spendthrift clause in combination with it. Well, maybe the meat and potatoes of the whole presentation, everything that we've covered till this point has been kind of preparatory. We know what they are, we know how they work. When are trusts needed? Okay, and one key thing these days, okay, back in the 80s is when sometimes we call it the living trust revolution got started. It used to be that everybody did a last will and testament, and then living trusts came along in the 80s as a way of avoiding probate, because everybody recognized that even if you have a testamentary trust under a will, the assets still have to be probated if your sole document is a last will and testament. And people started getting tired of paying unusually high probate costs, dealing with the publicity of probate, the delay of probate. So living trusts really caught on at that point, and they were really, for a while there, the only real probate avoidance device. Since then, however, to be fair, a number of other devices have come along, and those include beneficiary designations, transfer on death instructions, pay on death instructions, and joint tenancies. So if you're in a situation where your only goal, and this is pretty much most of us these days, unless you're above $11.7 million, which is the current federal estate tax exemption, and if you're married, you can double that number. Now that might not last till the end of the year this year, probably won't, but it'll still probably not be so low as to affect very many of us. If your only goal is to avoid probate, you can use something other than a living trust to deliver the assets to your heirs without probate. The only other consideration would be, do you want to have those assets supervised for those beneficiaries? For example, if you have minor children, that might be a good idea. If maybe a beneficiary, spouse or otherwise, is not very good with money or is susceptible to being swindled by undesirable people who are out there, maybe continuing on in trust is also a good idea. Those would be two indicators that even though you could avoid probate, a living trust is still probably a good idea. And that only deals with the probate that occurs at death. If you become incapacitated, there's also what we call a lifetime probate. Now, a power of attorney, in fact, two types of power of attorney, are the best way and practically the only way to go to avoid a living probate when it comes to your incapacity. A durable power of attorney for financial matters, and a healthcare power of attorney, which in Michigan we call a patient advocate designation. Those are essentials. Whether you do a trust or not, you got to have a health and financial power of attorney. That doesn't mean that a living trust can't be used to avoid a living probate. It can, and in fact, most financial institutions will still honor living trusts upon disability over powers of attorney. So again, if you have an alternate reason for creating a living trust, and primarily, we'll take a look at in a minute, when control is desired, still best to go with a living trust, even though probate could be avoided by these other methods. One caveat though, you do see joint tenancies on the list of probate avoidance methods. Be very careful with those, because when you put a child, for example, on an asset as a joint tenant with you, yes, the asset passes without probate to the child, but what happens if the child gets sued? The child is a co-owner with you, which means you've made that asset accessible to that child's creditors. So think twice. Is exposing assets to creditors or divorcing spouses, which become creditors of children, worth the savings of probate avoidance by using that technique. In a lot of cases, it's not going to make any sense. We're going to look at something else, like either beneficiary designation or living trust. Control. If you know that you want control over the assets after you pass on, then you pretty much have to use a trust. It's the only way to go. Beneficiary designations, transfer on death instructions, pay on death instructions give you no ability to limit the beneficiary in terms of how much the beneficiary is allowed to spend at any given time. And it also gives you no limit or way to limit who the receiving beneficiary, the person inheriting your assets, leaves those assets to when he or she passes away. So if we have young beneficiaries, we might want to postpone the delivery of all the assets, or even deliver the assets in stages according to specified ages. Keeping the assets in the bloodlines is another idea. In fact, nowadays, a very popular idea for those who are blessed with a lot more is to not put an expiration date on the trust. Michigan law was amended in 2008 to allow what are called perpetual trusts. Prior to then, a trust that you set up for your bloodline relatives eventually had to come to an end, maybe at the great-grandchild stage, maybe sooner. Now in Michigan, since 2008, you can run a trust in perpetuity, which means no matter how far the line of descent, as long as you have descendants, that those assets can be held in trust. And that's beneficial because if estate tax laws change, those assets are not exposed to future estate taxes. So if you have significant wealth that might be potentially subject to estate taxes because the exemption is probably going to come down, you might take another look at your estate plan and see if you've got something in terms of a perpetual arrangement. And if you haven't, maybe you should consider revising to get one. Only one estate tax is bad enough. Future estate taxes, when each successive generation dies, is really giving the whole kit and caboodle away. Lastly, sometimes we'll write trusts that kind of contain what we call carrot and stick provisions. And here we want to give financial incentive to good behavior. Maybe the income is sufficient to allow a beneficiary not to work. Is that the best for the beneficiary? Maybe not. So we see things like pay to my beneficiaries so much as shows on the beneficiary's W-2, the tax statement that you get when you have a job, right? So the better they're doing at their job, the more they get from their trust, which is supposed to give them incentive. You got to be careful with those provisions. They generally sound good, but they can be very difficult to draft and make them come out the way you want. A lot of times it's best to just give the trustee very broad discretion and then join that discretion with a letter that you write to the trustee describing to the trustee, here's how I want these assets to be distributed. Here are the important things that I want to see continued on, the values that I want to see passed on to my heirs. Let's talk a little bit about taxes. We're not going to get too heavy into taxes. Remember back when we talked about irrevocable trusts? The trusts that we'll be covering here now are irrevocable, and they do involve charity, as you'll see. So if you want to get a tax deduction for a donation to charity, but you don't necessarily want to give up the money yet, maybe at your death, you can do that by way of giving the future interest to charity and keeping the present interest. That's the second one on the list, and that's called a charitable remainder trust. The benefits there are you get a tax deduction when you put property into it. So for example, if you've done well in the market and you want to sell and you don't want to pay the capital gains all up front, think about doing a charitable remainder trust. You get a tax deduction for the full fair market value of the stock going in. When the trustee, which can be you, sells the stock, there's no immediate upfront capital gains loss. All the property, all the sale proceeds are retained in the trust. Now you do pay capital gains piecemeal as the property comes out, but economically that's better than paying the taxes, which can be federal and state, all up front. If on the other hand, you're in the mode of making gifts to the children because you know the exemption is coming down, you might look at taking that charity and moving it from a future interest beneficiary to a present interest beneficiary. When you do that, so for example, A to B in trust for charity, typically for a term of years, remainder or future interest to children, that's what we call a charitable lead trust. The word lead there describing the present interest, which when it's given to a charity, charitable lead trust. when tax deferral is desired. As I mentioned in my charitable remainder trust example, it's a lot economically better for you if you hold on to the tax money that you would otherwise fork over without a charitable remainder trust. So consider the economics of a charitable remainder trust in that scenario. Charitable remainder trusts are commonly thought to be estate planning techniques, but they're really not. They're really income tax planning techniques. With capital gains rates probably going up as well, we're probably going to be seeing more of lifetime inter vivos charitable remainder trusts as long as asset values remain appreciated. Last but not least, in 2019, we saw changes, significant changes, to the rules governing payouts from retirement plans. Now, as you're probably aware, retirement plans come in two varieties: traditional retirement plans and Roth retirement plans. So what I'm about to cover here only applies to traditional retirement plans because those have future income taxes that have to be paid. Even if you don't have to pay any federal estate taxes, the income taxes on retirement plans are something you cannot get out of. Okay? There is a rule that we don't want to confuse with retirement plans. If you own appreciated property and you don't pay any estate taxes under current law, the capital gains taxes in that property is forgiven at your death. But there's an exception to that rule for capital gains that are in retirement plans. So you're not getting out of that tax on your retirement plans, and neither are your heirs. The rule change that occurred in 2019 was that, in general, there are very few and limited exceptions, but the general rule that will cover most situations is that now children and other heirs who are inheriting retirement plans have up to 10 years to take the money out. So all the money has to be out of the retirement plan and thus subject to tax within 10 years. The rule prior would have allowed what we used to call the stretch out for as many as 60 or 70 years, especially if we were leaving these retirement plans to grandchildren. It was more of a life expectancy rule. But now it's only 10 years. So that increases the loss because typically that money coming out will drive the recipient into higher tax brackets. So it'll expose the money faster to taxes and probably to greater tax rates because of the tax bracket run-up that you'll probably see if you're an heir, having only 10 years left to take it out. Consider now leaving your retirement plan to a charitable remainder trust, not like in my example where you were the beneficiary up front, but a testamentary charitable remainder trust where at your death the plan pays into the trust and then the trust pays to the beneficiary for the beneficiary's life expectancy. We can get back for our beneficiaries life expectancy payouts, which means increased tax deferral, which can generally mean better economic results when using charitable remainder trusts as beneficiaries of retirement plans. The mechanics really quickly are the retirement plan pays into the charitable remainder trust and there's no income tax because, if you recall, charitable remainder trusts don't pay tax on what they make or have income on. The only tax due is when distributions are made. So the CRT, short for charitable remainder trust, receives the traditional IRA, puts it all back into the investments, and then we're off and running. But now we don't care about the 10-year rule. We're out of the plan in year one, and yet we still get to use the life expectancy of the child to make payments over. The one caveat here is that the child has to be old enough to qualify. So consult with your own financial and tax advisors to see if your children are old enough and if that strategy might be a good strategy for you. Well, that pretty much takes up all of the time for tonight on trusts, what they are, how they work, and when they're needed. Thanks again to Oakland University for allowing me to have the privilege of presenting to you tonight, and I look forward to handling your questions on the Q&A session coming up next. Good night.
Hello and welcome back. Sal, thank you so much for all of that information. That was really a wealth of information and explained in a very clear and concise way. You know, there are so many benefits to using trusts, and when you hear all of them really laid out clearly for you in a short period of time like that, not all of them, but many of them, they're very versatile, and that's really a wonderful thing when it comes to planning and planning for taxes, planning for your heirs, planning for your future. So right now we are going to head to our Q&A, and for anyone who still would like to submit some questions, please feel free to add them. I'm going to read you the first one. Sal, are you here, Sal? Are you ready?
I'm here, Colette. Thanks.
Okay, here we
Ready
go.
to go.
So what is the purpose of a ladybird trust? Does everyone need this in addition to a regular trust?
Yeah, ladybird trust is actually, the terminology is a little off. Ladybird deed. Ladybird deed. The idea is, how can we move a piece of property like a residence to heirs without probate and without using a revocable trust? In the presentation, we saw that, I named a few probate avoidance techniques that don't involve revocable or living trusts: transfer on death, right, designation, beneficiary designation, pay on death designation. What do you have when you have a house? Can you put a beneficiary? Can you fill out a beneficiary form for a house? No. But the ladybird deed is an invention that actually comes out of the Medicaid planning community that allows you to, not in the way I describe it, but has the same effect of putting a beneficiary designation on a house. You retain the property after you prepare the deed first, then you send it in for recording. The deed says that you retain the right to live in the property for life, and you retain the right to sell the property when you see fit, if ever. And you don't have to share any of the proceeds with the kids, typically, who are next in line to receive the property automatically. They're like the beneficiaries of the property on the ladybird deed. So in terms of the question, you wouldn't use a ladybird deed in addition to a regular trust. You may, but if you have a regular trust, you can avoid probate with that, a regular living trust. Typically, ladybird deeds are used in conjunction with those non-trust probate techniques. So I'll use a ladybird deed when someone tells me, I don't think I need a revocable trust, and I'll tell them, I agree. You got a big retirement plan, that goes by beneficiary designation. That's life insurance, that goes by beneficiary designation. So we don't need to use a revocable trust. If you're fine with your kids getting all the assets outright, how are we going to handle the home? Ladybird deed.
Okay. Good answer. Thank you.
Sure.
The next question. With the change in the White House, what vehicles do you anticipate seeing more of?
Probably that charitable remainder trust that I discussed in the presentation, Colette. And let me just supplement what I said there. I gave a little bit of time to the differences between an annuity interest and a unitrust interest, but I didn't connect them up with the charitable remainder trust and the charitable lead trust. So charitable remainder trusts can be charitable remainder unitrust. They can be charitable remainder annuity trust. The charitable lead trust, the same two ideas. So if we're looking at tax increases because of the change in the White House, then I would think that these, which are very popular during times where income taxes are high, because remember in the presentation, I kind of said that charitable remainder trusts are sometimes thought of as estate planning techniques, but really they're income tax planning techniques. Deduction up front, deferral of capital gains, pay as you go, when you're the beneficiary of the charitable remainder trust, and typically it's a unitrust. So the payments to you are growing if the trust is hopefully growing. And then balance to the charity. That generally tends to become more popular when, like I said in the presentation, assets values are elevated, but taxes and tax brackets are becoming elevated as well.
Sure, that makes sense. The next question. I set up a trust several years ago, and I am planning to move to a different state. What should I do?
Well, you probably have to get the trust reviewed by an attorney who's got a license in the state you're planning to go to. And that's now you might not find many changes need to be made to the trust that you have when you created it in Michigan for the questioner. But you will find, perhaps more importantly, significant changes will need to be made to your powers of attorney. Those other probate avoidance documents that I covered in the presentation. So how do we avoid that living probate? The idea that if I'm incapacitated, I want to pre-appoint people to make decisions for me so that the court doesn't have to take care of that job and my family doesn't have to go to the court to get that. So the powers of attorney are very state specific, unfortunately. And most attorneys only carry 1 or 2 licenses at most, meaning they are only allowed to practice in 1 or 2 states. Very common for If anybody, if any state here in Michigan, for a Michigan attorney to have maybe a Florida license second up. If you're going to another state, though, you're going to need to have, more importantly, probably, but all the documents reviewed, powers of attorney especially.
Okay, good advice. And a related question, how often should I update my trust?
Well, that's going to depend on circumstances. I was just meeting with a couple last week, a couple of couples last week, and we hadn't seen them in 20 years because nothing really changed. The trusts were set up when the kids were very young, minors. And the kids are still kind of moving along, you know, early 30s, still doing well. No one's gotten married yet. That's typically a trigger, unfortunately. Once you find out who your kids have married, you might tighten up your trust. But before that, it's really dependent on life events or tax changes. Okay, like I said in the presentation, we've got an $11.7 million federal estate tax exemption right now. That will most probably, it's already scheduled to come down in the law, Colette. It's scheduled to come down by half by 2026. We're going to probably see that accelerated, and then we'll kind of wait and see how much worse it may get. So events, right? Maybe a family member, unfortunately, may have passed away. Maybe the guardians that you named for the kids are no longer suitable. Maybe the kids themselves are at ages that you thought were high enough then, but now you're thinking maybe these ages aren't quite high enough now. So those kinds of ideas. Okay, so more often it's not an automatic like, well, every 5 years. A lot of these estate plans are in good shape. The ones I mentioned, I'm reviewing from 20 years ago. They're in good shape. We're just maybe doing some reconfiguring because now the kids can step into fiduciary roles. Okay, when they were minors, they couldn't serve as a trustee or a financial power of attorney or a patient advocate to make health decisions for their parents. They were minors at the time. So a lot of times we'll see those kinds of changes. So really more family event or tax law event specific. Okay.
The next question. Can there be a probate at my death even if I have a revocable trust?
Well, yeah. Unfortunately, there can. When you get a revocable trust, you always want to make sure that you take the time under your attorney's direction to coordinate your assets with your trust. Okay, so for example, if I have a bank account and I own it in my name and I sign a trust, okay, but I leave the bank account in my name as an individual, and I do nothing to designate the trust maybe as the pay on death beneficiary. Okay, it just sits there in my account, no one else on the account, my name only, no beneficiary designation. That's going to be a probate asset, even though you have a revocable trust, even though you have one. Now, that's why you'll typically get with your revocable living trust another document called a pour-over will. The pour-over will do the job of delivering that asset to the trust because it wasn't delivered to the trust in any way by way of a lifetime arrangement, more typically transferring title into your name as trustee. So unfortunately, with respect to that asset, you kind of wasted your money a little bit when you spent it on getting the trust because it didn't do the job, but you got to coordinate with it. It's not automatic. A lot of times people come to the office and they sign off on their estate plan and they think they're done, and they're really not. It really just gets started. You know, you buy a car, you're not done. You got to put gas in it and start driving it, right? So when you get your trust, it's kind of like that. You want to start using it and coordinating your assets with it.
That's a very good point. And
be careful.
Yes, that's why people need to speak to advisors, professionals, people with the right credentials. This isn't really a do-it-yourself kind of situation, although there may be some forms available out there. Seeking the help of a professional and the insight of a professional is always.
Oh, absolutely, Colette. And it can be any type of professional. A lot of financial planners, CPAs, gift planners like yourself, they know these things too. So
I can't give advice.
We know that.
I can talk about things, but I can certainly.
An easy question to ask. So are all your assets coordinated with your trust? And then leave it at that.
That's right. That's right. One last question. Can I save income tax with a revocable trust?
No, you can't. A revocable trust, because of your right to revoke, is tax neutral. In fact, a revocable trust is ignored when it comes to income taxes. It's as if you never did anything. The technical term for that is grantor trust. Okay, a grantor trust is a trust that, like I said, is ignored for income tax purposes. It doesn't file its own tax return. All of its income and all of its capital gains go on to the tax return of the person who set it up. And that's generally a good thing. Okay, it's generally a good thing. And that's for reasons I don't need to get into. Those are some technical reasons. So sometimes people do think that they can do that with a revocable trust. You cannot. Okay. So let's not be misinformed. And just kind of an add-on, generally, Colette, a question that kind of resembles that. Can I protect my assets from my creditors if I create a revocable trust? And the answer is, again, no. Your right to revoke defeats any creditor protection you might think you're accomplishing. Now, you heard me in the presentation say if you leave a trust to the kids, especially a discretionary trust, that's a different story. And the reason is the kids didn't set up the trust, you did. So from a creditor standpoint, you're not in very strong a position because you're right to revoke. But remember, when you pass away, that right goes away and the beneficiaries are the kids and they didn't set it up to start with, so they're on much stronger ground.
I see.
Make sense?
Makes sense. It all makes sense. Thank you so much, Sal, for your expertise. Thank you again for joining us, to everyone. We have no other questions right now, so we truly appreciate your time and your information. And thank you again to everyone for joining us for the information. And if you are interested in future Oakland on the Road events, they are taking place this week. You can check out oakland.edu/alumni and sign up for a few more sessions. Thanks. Have a great day, everyone.
Thank you.